Let's see. Okay, I guess I'm going to start by reading the obligatory American Constitution Society statement, which is, for those not familiar with ACS, we are a national network of lawyers, law students, scholars, judges, and policymakers who believe that the law should be a force to improve the lives of all people. ACS works for positive change by shaping debate on vitally important legal and constitutional issues through the development and promotion of high-impact ideas. We've got a couple students whose names I don't recognize. If you guys haven't joined ACS, you can officially join the national organization at acslaw.org. You can also email me at agarrett18@student.gsu.edu, and I can get you in touch with more information about what we're doing this semester and how you can get involved in the fight for justice. So usually ACS panels are about how to interpret constitutional issues, how to work with the text that we have, but I thought that it'd be good to start the year with a discussion about what's not in the Constitution but should be. So the way that I see it, there are two main ways to kind of frame this question. There's sort of what is unclear or completely not mentioned in the Constitution that's frustrating for the legal community, and what are the rights that we're missing that really belong in the Constitution of a civilized society. There's a lot of people discover every election that there's not a right to vote in the Constitution, and there's not a right to privacy. There's a lot of things that have just been kind of read in or people just assume are there. So our panelists today are Dr. Richard Winfield, who's a candidate for US Senate and a professor of philosophy at the University of Georgia, as well as 3 constitutional law professors at Georgia State. I'm going to let them introduce themselves and describe their views on what the Constitution means and what needs to be added to it. And so with that, I'm going to turn it over to Professor Richard Winfield.
Okay, thank you. I've been teaching philosophy, by the way, since 1982 at the University of Georgia. And part of my work involves conceiving the institutions of freedom, and I've laid out why freedom has exclusive normative validity and what the institutions are that bring it to reality in a series of books, including Reason and Justice, The Just Family, The Just Economy, Rethinking Capital, The Just State, and other books that include various kinds of essays. I've also run on 2 occasions for national office, once for Congress a couple of years ago, and now for Senate. In both cases, I'm frankly trying to address what I think is the biggest hole in our Constitution, and that is it is fundamentally incomplete. A Constitution should give guarantees for all of the rights that make up the totality of freedom, none of which should be violated with impunity. And political freedom is not something that can be exercised if our freedoms at home and in society are obstructed. But our Constitution has nothing to say about our fundamental family and household rights. Now, there have been calls to rectify that omission. FDR, of course, in his famous 1944 last address to Congress, called for a new Bill of Rights. The rights in question were then put into the Universal Declaration of Human Rights. Signed on by almost every country in the General Assembly. Our nation really did not do anything about putting those rights into our Constitution, let alone into positive law. And so 25 years later, Martin Luther King put out the same call for a social bill of rights as part of his final campaign for a Poor People's Campaign. Now, the rights in question include such things of which there's no mention in our Constitution, of the right to a livelihood, a decent livelihood, without which one can hardly exercise any of one's freedom. That involves a right to employment if one is able to work. It involves a right to receive a correspondingly equivalent decent income if one is unable to work. It involves the right to be able to have fair representation as an employee, both in terms of unionization and seats on corporate boards. It involves the right to health care. It involves a right to a healthy environment. It involves the right to decent housing. It involves the right to be able to balance work and family and have such things as paid leave and child care and elder care and sufficient income to support one's children. It also involves the right to education, which is completely absent in our Constitution, and the right to education at all levels. And it also involves the right to access to culture, and also the right to legal representation in all kinds of cases. Our Constitution notoriously says nothing about providing legal representation for civil representation, which is crucial in defending our rights at work against sexual harassment, racial discrimination, employer abuse, etc. Now, this represents a whole body comprising a enforcement and recognition of pre-political rights that are crucial to exercise political freedom. And they need to be put at the center of our political agenda. That's not to say that there are not failings in what is in the Constitution regarding the exercise of political freedom. For example, we need to get rid of the Electoral College. We need to deal with the Senate, which is a fundamentally anti-democratic institution, either by relegating it to relative political impotence like a House of Lords, or alternately by changing the boundary of states. So we don't have those ridiculously unfair differences in per person representation in terms of the Senate. We also need to deal with having nonpartisan districting. We need to ensure that we have reasonable campaign reform so that all actors on the political stage have fair access to gain the voice, to get to the people and so forth. And we also have to deal with the way in which the authorizing function, which is what will establish the constitutionality of law before it goes into force, is properly handled. Because presidential vetoes can be overridden. Supreme Court review of the law doesn't come into place until after it has been in place. These all endanger the very fabric of constitutionality, and we need to have revisions in that regard. Thank you.
All right, that's terrific. Next up, we're going to hear from my constitutional law professor, Professor Neil Kinkopf.
Hello, everyone. I, in one sense, agree with everything Professor Winfield just said. I am substantively committed to all of the good and just things that Professor Winfield wants to put into the Constitution. I disagree, though, that we should put them into the Constitution. I think as a practical matter, amending the Constitution is incredibly difficult, verging on impossible, especially for the goals that Professor Winfield wants to pursue. Setting aside the pragmatic point, I think the more crucial thing than having the words enshrined here or there in a constitution or in a statute, the much more important thing is that those values be actual commitments of our polity. If they aren't, then having them in the Constitution isn't going to do us any good because they won't be able to be effectuated. And if they are, then having them enshrined in statute will be more than sufficient, right? So I tend to think of, say, Social Security. If you want to lose an election for office, I suggest perhaps the easiest way to do that is to suggest abolishing Social Security. Presidential candidates very often run on a platform that includes an allegation that my opponent wants to end or undermine Social Security. It's an incredibly durable and popular program, and I think that's the key point, right? It's never been enshrined in the Constitution. It's protected through politics. And I think most of the positive and good things that Professor Winfield is suggesting are much better enforced through the political system, so that our minimal constitution strikes me as a better way to go. Leave it minimal and pursue these goals in the political arena. That's all I have to say.
All right, and now next up we have Professor Anthony Kreis.
So I think I share the same, commitments to the things that Professor said, and I echo the kind of sentiment um, that a lot of these things are well and good, but I don't think that they belong necessarily enshrined in the Constitution in an express way. For me, what the Constitution could bear to have more of are representation reinforcing reforms. So things that make it easier to vote. So an affirmative right to vote could be helpful. But then again, right, if the body politic doesn't really buy into that, then you're going to have voter suppression statutes, right? So I think, as a general principle, if we can read into the Constitution some greater protections for ensuring representation, or ensuring that our political bodies look and represent and feel like the people, that's good. So the Senate is problematic, and there are issues there. I think we could talk about it later, but I think there are ways to improve the function of the Senate without actually having to attempt to abolish the Senate or anything like that. Ultimately, my take is there are things that I wish we did have enshrined in constitutional law. I do wish that we had a strong right to an education. I do wish that there was more of a sense that there's an affirmative right to vote, and there's a duty on behalf of the state to make it easier to vote. So there are a lot of those things. But the beauty of our Constitution is if you have the political will and you win at the ballot box, and if you have successful social movements, those things can be read into the Constitution. I think the Equal Protection Clause can do a lot of work, but you have to win at the ballot box first, and you have to secure majority support for those propositions before those things can come to fruition. The one thing I will say before I pass off to Professor Segall, I do think that the Supreme Court needs some reworking as structurally. There is no way that we can continue to go down this path that we have gone down for a while now, where people's rights and liberties and the outcome of cases depends on the health of octogenarians. Like, that is not a functioning democracy. That is a bad way to operate a republic. And so, certainly for me, having 18-year term limits, for example, for Supreme Court justices to have regular, routine, predictable turnover of the court's personnel, that to me is one structural thing, which I do think the Constitution should be amended to reflect. But a lot of these other kinds of social policies, for example, I don't see the value necessarily of enshrining them in the Constitution or placing them in the constitutional text, because if you're able to do that, then you're certainly able to do it right through legislation and have robust public support for those kinds of things. So I think that you have to go to the ballot box. And that's where these things are ultimately, won or lost, right? It's people voting, it's electoral outcomes, and then it's having political bodies that have the political will to enact these kinds of things in the law.
Thank you. And then finally, Professor Eric Segall.
Thanks, Alex, and thanks for organizing this as the first meeting of ACS this year. This is great. So throughout American history, it is undeniable that the United States Congress has been to the left of most of American politics and the Supreme Court of the United States. Congress tried to end slavery in the territories in 1857. The Supreme Court said no. Congress passed a civil rights bill in the 1870s prohibiting segregation in theaters, restaurants, and places of public accommodations. The Supreme Court said no. Congress tried to end child labor in the 1900s. Congress said no. Supreme Court said no. The Voting Rights Act, Supreme Court said no. And I could go on and on and on and on and on. So the crisis we're currently in that Anthony so correctly points out is in large measure due to a failed idea that judicial review should be strong and should be substantial. I will concede that along the way there have been states, mostly in the South, that have been to the right of the Supreme Court. But we need a national solution to our national problems, many of which Professor Winfield points out very astutely. We do need a right to health. We need health care for everybody. We need employment for everybody. You know, these are goals. We need a minimum wage that's real and all of that stuff. And throughout American history, the story is the Supreme Court gets in the way of all of that. So the first and most important thing that we need to do, and I have been yelling this for 20 years with ACS usually yelling back at me, but even though I'm a loyal member, but now it's time for ACS to change. We need to weaken the Supreme Court. And I actually think the American public would go for weakening the Supreme Court. So term limits, which I'm obviously in favor of, Anthony, have been for a long time, aren't the answer though, because term limits don't really weaken the Supreme Court. We need, it does a lot of good things, but it doesn't really weaken the Supreme Court. We need to weaken it. We need to make it do less. So there are several ways to do that. One way would be to require 2/3 or 3/4 of the justices to agree before they strike down a law. I think that is a constitutional amendment the American people would get behind. More importantly, though, I think that we already have the tools non-constitutionally through jurisdiction stripping to reduce the Supreme Court's power, or at least scare them into exercising it. There are also very minor things that we can do. We can make retirement much more attractive through all kinds of severance and retirement. No, I'm serious about this. This has been done in the past. But mostly what's missing in the Constitution is a way to limit the ability of the Supreme Court to get in the way of progressive national legislation. So in that regard, what is needed is something that will make the justices very, very afraid. And maybe jurisdiction stripping is the answer, but I prefer to see a standard of review built into the Constitution. We can take Alexander Hamilton's. Laws can only be struck down by the court if they can show there's an irreconcilable variance, those are Hamilton's words, between a statute and the Constitution, require 3/4 of the justices to do it, and maybe even like Canada does, giving Congress the ability to overturn a Supreme Court decision by, let's say, 2/3 vote of both houses or something like that. We can be creative in all of that, but what Professor Winfield, I think, needs to come to terms with a little bit is that in America anyway, rights don't work. So I agree with Neil and Anthony that most of this has to be done by majorities, and we have to figure out a way to bring majority rule back to the United States. Thank you.
All right, so a lot of different perspectives. I mean, a lot of the rights that people, most closely associate with American society have come from the courts, like the Miranda rights, privacy, gay marriage, desegregating public schools. And so I want to ask all the panelists, I mean, why, could we have gotten all of these things through kind of narrower statutory measures? And why didn't we? I mean, gay marriage, I remember in the 2008 campaign, Obama and Sarah Palin having the same position that, there shouldn't be outright equality for homosexual couples. There should be a civil union or some kind of half measure. But in a few cases, the courts have taken these broad constitutional guarantees for equality and free expression and other things and produced results for American citizens. So, I mean, why not, codify more broad guarantees and then leave it to the courts to, have those litigated?
Alex, if I may, since I went last, can I go first this time?
Sure.
Your assumption is inaccurate. Your premise on that whole thing is inaccurate. So Brown versus Board of Education formally ruled, segregated schools unconstitutional. On the ground, it did very, very little. Very, very, sorry, that was some noise there. Did very little. For 10 years after Brown, the entire South was still segregated. And what stopped that was Congress, not the courts. Same-sex marriage is an exception to the rule that I think American history provides, that the court cannot force progressive change. The court can stop change and has done so repeatedly since 1857, but it can't force it. And the only reason, and this is really important, and I'll stop, it's kind of like the only reason that same-sex marriage worked out the way it did is because Bork and Ginsburg didn't get the nominations that they were, that were first given, and Justice Anthony Kennedy had a mentor who was gay and closeted, who he was very close to, and Justice Kennedy was devoted to gay rights throughout his career. That's just luck. That's not the system. Give me Bork, give me Ginsburg, it doesn't happen. Give me Kennedy without the gay mentor, it doesn't happen. So I think I just want to correct the premise that it is the court that has produced these good things. It is not. It is normally the elected branches and normally Congress.
So I just want to jump in here for a second. First of all, the Ginsburg you were just referring to, Eric, is Douglas Ginsburg, just so people know. And I'm being a little puckish here, but only a little. If your goal is to weaken the court, then wouldn't the best way to achieve that be to pursue Professor Winfield's suggestion and put all of these grand positive rights into the Constitution? Because the court will issue an order that John Doe be given a job and a living wage and health care, and then nothing will happen. And so the genius of Marbury is Marshall figured out a way to resolve the case without ordering Jefferson to do something. I think what would happen if we followed the road to adding in substantive positive rights into the Constitution is we would see those rights not getting effectuated in practice and court orders being effectively flouted. And so I think if your goal is weakening the court, that would be a pretty good way to do it.
Is that a question for me? I take it. I don't know. That world is so foreign from the world we live in. Here's what I know. It doesn't matter what you put in the Constitution. In a system of judicial review that is supposed to enforce a document or a document's broad meaning, over time, change will be harder to do. I mean, I think what ACS is about to a substantial degree is when change is needed to the status quo, we should change and be, quote, progressive. The definition of judicial review basically is backwards looking. Scalia had this right. He said our job was to enforce a document written in centuries ago. It's not our job to force change. He was a hypocrite completely, and he didn't act on that. But when he said that, it's a fair indictment of a system of judicial review, which is by definition backward looking, and therefore by definition not progressive, and therefore for progressives, we should not want that kind of system.
Could I respond to some of these comments? I mean, I agree with my colleagues in acknowledging first the difficulty of amending the Constitution. Also acknowledging that, if the Constitution or any part of it does not have wide popular support, it's an empty writ. But I think we all know that without rights being specified in the Constitution, it's very easy to use the 10th Amendment to the Constitution to say that, well, if these rights are to be given any kind of power, it's left to the states and to their license to decide what to do. And that means that if we take legislative initiatives to, for example, have a federal job guarantee, or to have Medicare for all, or to have guaranteed housing and so forth, it's very possible for courts of a certain persuasion to do what happened under the New Deal, that is strike them down and saying that these are not specified in the Constitution. Now, admittedly, it's difficult to get a second Bill of Rights enacted. But if it were to be enacted, it could counter these problems that positive legislation faces. It would also be something, because of the very difficulty of getting it enacted, would have wide political support when it is finally enacted. And after all, there have been meaningful amendments to the Constitution that have changed the fabric of our nation for the better. And I think, I think we don't want to weaken the Supreme Court. Admittedly, I think the way it's set up defeats its own purpose. The lifetime terms were supposed to provide a certain kind of insulation from, political fashion and the like, but in a way it locks in a particular political fashion for the lifetime of these people. And I think it is important to have a single term that is limited. I think 10 years would be enough. I think we can increase the number of people in the court and have the terms staggered, so no individual administration can tilt the court for a long period of time in its direction. But I think we also have to think about the task of having progressive legislation, hope it is not challenged by the Supreme Court, but also think about the avenue of constitutional amendment as well.
So I'm going to jump in. And so I have the perspective of, right, we have these big eras in constitutional law where the courts do certain things, but you can trace the ideology of their constitutional jurisprudence back to the on the ground politics. So yes, the Supreme Court did a lot of terrible things with civil rights and progressive legislation, basically from the 1860s until the 1930s. But that's because the Republican Party dominated the federal government for all those years, by and large. They adhered to an ideology of free labor, which gave rise to a whole, a capitalist industry with a financier class, and the constitutional jurisprudence kind of followed the ideology and followed the politics. The reason why we had such a, I'm a big devotee of the Warren Court. The reason why we had the Warren Court is because you had decades of Democratic dominance, liberal dominance, and there was an ideology that came out of the late 30s and 40s that we had to find solutions that were progressive, where the government took an active role in people's lives and economic policy. But there was also coming off the 30s a question about, well, how do we preserve American norms and traditions and democracy and a liberal society, in a way, and still have these programs and not fall into the trap that Europe had. And of course, you get Brown, which is kind of, I think, in many ways, it's a vindication of civil rights in America. It's one of our landmark cases, but it was also a byproduct of, well, what are other countries looking at us? And seeing what we do to our own people, how does that respond, or how does that square with our international policy and our kind of how we project ourselves to the world? Same-sex marriage, that's kind of the slightly different case. I think 98% of constitutional law is a byproduct of those dominant coalitions, Republicans, Democrats, and New Dealers, Reagan coalition. Same-sex marriage, is kind of the exception, which is, if you have a successful social movement, I think eventually that successful social movement manifests into law. And it took a very long time in order to get to Obergefell, and multiple steps and multiple paths of litigation in state and federal court. So for me, I think a lot of the debate about amending the Constitution is not, that's the wrong conversation, because what we should be asking ourselves is, does the Supreme Court reflect majoritarian norms? And historically, it has, and oftentimes that has had bad consequences. But right now, we are at a moment where the Supreme Court is for the first time truly a counter-majoritarian institution. It does not look and reflect the average sentiment of the average American, and it's I think we're headed in a place. Kind of like what Professor Winfield was alluding to, like the Hughes Court in the 30s, where the court is, for the next 10, 15 years at least, unless something happens, is going to fundamentally, be a thorn in the side of any progressive initiative that comes to fruition. And I think we have to ask ourselves, how do we make the court more majoritarian? How do we undo and unrig the damage that has been done to the courts, and to the Supreme Court in particular, from the Garland nomination failure to the Kavanaugh debacle to what we're about to see probably for the next few months? So I think that's the real question: is not necessarily weakening the Supreme Court, but I want the Supreme Court to be more majoritarian, and I want to undo the counter-majoritarian impulse I think that the Supreme Court has now, and is only going to get worse in the next few years.
It's not just this. I agree with a lot of what Anthony just said, but it's not, although I think the Warren Court was an aberration over 200 years, but leaving that debate aside, Our entire country needs to be more majoritarian. I mean, so Richard, I think your goals would be thwarted by the Senate as often maybe as it would be thwarted by the Supreme Court in the long run. I think we need a way to change the Senate so that Montana doesn't have the same power as California. We definitely need to get rid of the Electoral College and vote for the president through a national vote. All of these things, because I agree at the end of the day with Anthony that we, especially as America becomes much more diverse, religiously, ethnically, racially, and so on, we need to restore majoritarian politics. Restore is the wrong word because the founding fathers were against majoritarian politics. We need for the first time to really ensure that majorities can rule. I don't mean majorities in Georgia or California. I mean majorities in the United States. I used to kid Professor Kinkopf, and maybe I had this wrong, but Neil used to say something along the lines of state lines are okay, but we don't really need them for legal purposes. It's okay to have a geography boundary, but we should abolish them for legal purposes. I used to tease him about that. I've now decided you've been right and I was wrong all along. For the first time in our relationship, you were right and I was wrong all along. We need a way to bring the majority of the American people into governing the American people.
Could I just bring 2 points to bear on that, which might seem to go about against what I was saying, where I was talking about a new social bill of rights. First, with regard to the Supreme Court and making it an institution that both has a proper independence and does not get captured by a particular anti-democratic political movement. Article 1, Section 1 of the Constitution gives Congress control over the entire federal courts regarding their size, terms, and so forth. So you don't need any constitutional amendments to transform our federal court system and the Supreme Court. Congress can do it if it has the foresight to do that. On the other hand, regarding the Senate is the one institution that our Constitution forbids us from ever amending with regard to its basic principle of representation. Namely, it has to remain for eternity, or at least as long as our Constitution.
It's a parchment barrier.
So I think but that doesn't mean we can't do things. And one way of doing it is either reducing the powers of the Senate, which can be done, or alternately changing the borders of states in a way that would more evenly distribute Senate representation.
So I just want to say something about the Senate. I think one of the things that we can do in order to make the Senate more representative and kind of eliminate some of the problems that we have with state lines and is we just need a new filibuster rule, which is unless you have a number of senators who represent a majority of Americans supporting some kind of legislation, then it's dead, right? So you need to have some kind of majoritarian support, and not just 51 senators. You need to have a number of senators who represent a majority of Americans. One of my biggest pet peeves over the last few years has been the last two Supreme Court nominees, the last two justices put on the Supreme Court. That not only was it appointees put on the court by someone who won just through the Electoral College and not through not securing a majority, but you had a number of senators who for the first time ever did not represent a majority of the population, pushing the nomination through and getting them confirmed. So I think that the Senate rules are going to be our best friend there, where we can be innovative and we can find ways to make it more majoritarian in nature, without having to go down the route of talking about or debating the extent to which we can abolish the Senate or reduce its power otherwise.
We have a special guest, GSU criminal law professor Bill Edmondson, and I think he might have a question. So I'm going to try to unmute Bill.
Yeah, this is for Professor Winfield and the panel. I've heard very little reference to the case of Roe versus Wade. One of the positive aspects of judicial review of fundamental rights cases is the emergence of that right or one of its most deplorable aberrations. I'd appreciate each of you just saying briefly what happens to Roe if the reforms that you advocated were followed out to their logical extent.
I mean, my own view, frankly, is that one has complete reproductive freedom. One actually achieves the goal of the pro-life movement by reducing abortions to their humanly possible minimum. And what I mean about true reproductive freedom, I'm speaking about not only the right to abortion, and to fulfill that right, that it be covered by a public health care system, as well as all kinds of reproductive health matters, but that one provide parents and women in particular with the economic independence and the balance of work and family so that people can afford to have the children they want to have, which I think is one of the obstacles that in a way prevents women and people in general from really having the ability to choose what they want and not face these compulsions that make them do things they would otherwise not do. And I think under those conditions, abortion would be reduced to an absolute humanly possible minimum. And in that way, I think one can defeat on their own terms the pro-life movement. And in that way, I think the social rights agenda that I'm proposing, whether it be enacted through congressional statute or ultimately by constitutional statute, would allow for that and, in a sense, make Roe versus.
So with the caveat that I am pro-choice all the way down and always have been, always will be, I think there's a lot to learn from the fact that of the 100 panels I've done in the last 10 years where abortion has been raised, it is always raised, always, with reference to Roe versus Wade. Professor Edmondson is an incredibly sophisticated, knowledgeable law professor who knows that Roe versus Wade hasn't been the law of the land since 1992. The law of the land is Casey, not Roe. And Casey dramatically changed Roe. And my point about that, Alex, is that Roe as a symbol has killed the left. I'm going to say that, I would say it 15 times if I could. Roe as a symbol has killed the left. We have Trump because of Roe. Reagan and Meese in the late 1970s did a phenomenal job of convincing evangelicals that they should care about abortion because they didn't before that. Jerry Falwell was asked in 1997 or so, do you care about abortion? Nah, not a big deal to us. We have other priorities. They brought the evangelicals into the fold on that issue because Falwell saw it and Robertson saw it as an avenue towards power and money. And Roe as a symbol is the reason we had Donald Trump as president. And so the only way that we can get to a world where women have complete and total reproductive freedom in a way that doesn't destroy the left is not through the courts. It's through education. I have been counseling Planned Parenthood for a decade to really spend their money on going into schools and talking about the need for women to control their own destinies. And I think anyone who wants to defend the Supreme Court from the left needs to say that Roe was a tremendous mistake. I can go in the Q&A, I can discuss that more, but Roe was a tremendous mistake by the Supreme Court, and we've been paying for it ever since.
I'm gonna defend Roe. So I think the New Deal coalition was on its last legs when Roe when Roe was handed down, right? And so the Reagan era or something like it was inevitable no matter what the court did with Roe or what the court was doing in the 70s generally. And I think that just from my side, like the political scientist in me says that, right, we have, I've referenced this idea of a dominant coalition. Right, oftentimes there is a very dominant ideology which lasts for four, 5, 6 decades, and then you have this reconstructive moment where the country rejects it and kind of unsticks itself from that ideology, and starts from scratch, so to speak, right? So you had the New Deal era, you had the radical Republicans, you had the Reagan coalition. And I just think I wouldn't blame Roe for that. I think the question is, for me, is Donald Trump the Jimmy Carter, the Herbert Hoover, the James Buchanan of our time, and are we going to see that next reconstructive moment? If the answer is yes, then that the American people will reject the last 40 years and reject Donald Trump. I think Roe, we're going to see a very different Supreme Court for the next 40, 50 years. One that not only wants to protect Roe, protect Casey, or expand Casey really, but will value not just the right to access abortion, but will value the concept of reproductive justice, which is a lot more comprehensive than just the right to abortion. But ultimately, again, I think that's we're going to find out in November where things are going to head there. And the only way, I think the only way that we can secure these rights is to make sure that we win at the ballot box, right? That's really what we have to do, because we can talk about the courts all day long, but ultimately, if you're losing elections, then you're not doing yourself any good. You're not going to be able to reshape the courts. But I'd go back to this idea that by the time Roe was decided, the New Deal coalition was crumbling already. It was disjunctive in a way that I think the Reagan coalition is fairly disjunctive now, right? I mean, just look around us; nothing is going well. And so, if that's true, then we have a real opportunity not just to win an election, but to win an election for liberals and Democrats and progressive causes. In a way to fundamentally rechange the way the political system works, and to fundamentally change, some of these dominant ideologies that we've been dealing with for the last 40 years. So I'm going to defend Roe and say it wasn't Roe, but I do think it's important, right, that we do talk about reproductive justice, and that whatever happens for the next 10, 20 years, that I think we need to be a little bit more aggressive as liberals and progressives about talking about, the constitutional right to reproductive justice, but also to push legislation like what Illinois did a couple of years ago. I mean, that's progressive, proactive legislation is in my mind even better. So I guess I agree with Eric there.
I have more questions I want to ask, but are there any people in the audience who would, do you have something, Professor Kinkopf?
I did, but we can move on. That's fine. I think we've said enough about Roe.
I just want to give people in the audience an opportunity to ask a question. You can either raise your hand or just jump in. So is anyone curious about something? While people are kind of Marshall. Oh, hey, yeah, go ahead.
Hello, I have kind of two questions for the panelists. So the first one is, although we do understand that it's very important to have a majoritarian rule, but the concern is how can we deter the tyranny of majority, and how can we protect minority if that is the only rule? And secondly, as the America become more diverse, well, I think that a key for the coalition is to have a minimum claim about what we have in common. If we have a maximum claim as what we have in common, then I think it's really hard to form a coalition if we are truly diverse. We have different opinions. So how can we reconcile that? And I do understand there's national problems and probably require national solutions. But the problem is that kind of expansion of government power is kind of scary, especially for someone like me have backgrounds living in authoritarian countries. I think that is a real concern. We can't just suddenly kind of subvert the system, and that the politicians, they have so much power as to dictate what kind of human rights it should be, how to enforce it, how to protect it. I think ultimately it should be, there should be some kind of mechanism, kind of precautionary measures, as Madison talked about in Fetcher's paper. So that's my two questions. Thank you.
Could I respond to at least a big part of that? Because I think what is fundamental to preventing the tyranny of the majority, and what is essential for there to be any kind of constitutionality whatsoever, because it is constitutionality which in a sense sets limits to what any political agency can do in a republic. And a key to that, for there really to be constitutionality, is that there be a separate authorizing power, different from the legislature, different from the executive power, which is in the position to prevent any legislation from becoming authorized and valid without its confirming assent, and also is in the position to annul any executive action that it deems to be unconstitutional. Now, what we have as an authorizing power is divided up between presidential veto and something that wasn't even really in the Constitution, namely the review of a Supreme Court. These are not sufficient because we all know presidential veto can be overridden. Moreover, it strikes down laws that are constitutional but are simply against the political views of the president. Secondly, the Supreme Court only takes up cases that are brought before it after a law has been passed and gone into effect. I think if we really want to have an authorizing power that properly allows the Constitution to have some reality and prevent either the legislative power or the executive power from doing as they please, we have to have something that Kelsen recommended, namely, you have a kind of authorizing judicial body that has to give its assent to any passed legislation before the bill goes into effect. And that is mandated. Then you also have to have an authorizing power that is observing executive actions, monitoring them sufficiently to annul them. And the key point is that the authorizing power cannot do anything positive in its own right. It can only annul legislation, and it can only annul executive action, because if it could take positive measures, then it would be supreme in a way that would erode constitutionality. So I think we have to come to grip with those difficulties that I think do require systemic changes in our whole constitutional fabric.
So I'll just say that many years ago, a law professor named Mark Tushnet wrote that yes, majority tyranny is a problem, but who is going to control the judges? And that is a very, very tough nut to crack, right? There has to be a balance between I agree that there are some things the majority should not be able to do. But if we give judges the power to decide that, how do we limit the judges? And that's Adam, it's a great, I think it was Adam who asked that question. It's a great question. And philosophers and law professors have been fighting about it since around 1857. I would only say that that I think it was Hayek who said in the 1920s, where a constitution is clear, then judges should enforce it. And by clear, I mean really clear. The president has to be 35, whatever. Where the Constitution is fuzzy, why would we, leaving aside courtroom issues, double jeopardy, self-incrimination, confessions, judges should control those. But when we're talking about abortion, affirmative action, campaign finance reform, fundamental rights, why would we delegate that to Justice Kennedy or Justice O'Connor or whoever, or Justice Warren? It doesn't make any sense. So I think, Richard, the key is to find some way to dramatically limit the veto power of the court to what the Constitution says, have the Constitution say good things, amend it if we have to. But Adam, your question has been vexing philosophers and legal scholars for centuries.
I want to jump in. There's, packing the court is something that wouldn't necessarily require a constitutional amendment, but it's certainly relevant to our discussion today. If the Supreme Court, if there's just this urgent issue in lots of moments where the Supreme Court is staffed by holdovers from old political wins, and now there's the potential for a political movement getting vetoed there. So do the panelists want to say anything about whether an incoming administration should consider adding justices to the Supreme Court, or something along the lines of the FDR plan where there are apprentices or something who get a full vote? Or is there some other way that the Supreme Court can better keep pace with public will?
I'll dare to jump in, because I think, you don't just want to pack the court and leave things as they are, because that simply means you're allowing a particular government to basically make the court serve its interests. And under the current organization of the Supreme Court, lock in the country to that majority for decades to come. So I think it's not a matter of simply appointing new justices who have lifetime terms. We can enlarge all of the federal courts, but do so in a way where we have no longer lifetime appointments. There should be a single term, so judges are not subject to any kind of pressure which might bear upon their re-election chances. And they should be staggered in their appointments so that no individual administration can, in a sense, take over the entire court system and have it do its bidding. But I think we are locked in currently in the current situation, and I think it warrants reform. And I think to begin with, we can add additional justices, but under the proviso of setting term limits, single terms, staggered terms, and do it in a way where no particular administration can, in a sense, dominate the court system and make it its tool.
So I think we're witnessing the court being packed, right? Merrick Garland abuse was the first step, Mitch McConnell manipulating the process to yield his own packed majority on the Supreme Court. We see McConnell and the Federalist Society packing the lower courts as well. And I think if in January we have a President Biden with a Democratic Senate, they should try to unpack the courts. And it may be that to unpack the courts requires adding seats. And if that's what it requires, then that's what they should do.
So I am of the mindset that we should stop calling it packing the court, but we should talk about it, unrigging the court, because that it just seems to me, right, that the only aim of this administration and the majority in the Senate is to cement power that they have not really earned. They know that they are, they represent a minority of Americans. They know that their positions generally are not popular. They know that's not going to get any better with, for them over time, because Americans are increasingly diverse, increasingly progressive. And so this is their last, grasp for long-term power. And so I think that, absolutely that, if this nomination goes through in particular, progressives and Democrats, we need to add those two, at least two members to the Supreme Court to undo the harm. And I think that, again, kind of like what I've referenced earlier, there are these moments in time where you can see the dominant, ideology, the dominant outlook changing. And so to me, this is no different than what happened in the late 1860s when, Andrew Johnson is now president, who is fundamentally opposed to the dominant regime, right, to building a reconstructed America. And Congress said, no, President Johnson, you don't get to appoint members of the Supreme Court. We're going to start abolishing seats. So like, to me, it's a very similar moment that, you have a president who, this point in time, you've got a Congress or Senate that are incredibly regressive, that do not, or know that their time and power is waning, and we should not permit them to get away with it. And frankly, the one thing that bothers me is I think too often Democrats and liberals and progressives have these principles that they believe in, and then they unilaterally disarm. And I think the time for unilateral disarmament should be over, and we need to be aggressive, and we need to assert, that we need to be more assertive in our claims to restoring the court to something better.
I think that the Democrats, if they gain power, should restore the court to some balance that it was in prior to the Garland fiasco. But I think a much better solution is, and also at the lower courts, as Professor Kinkopf said, I think a much better solution is to package that with a proposal to seriously weaken the court. Abolishing term limits is, abolishing life tenure is an incredibly popular idea. So if the Dems can say, we are going to undo what McConnell did, but all that means is that Republicans can then undo what we do 20 years from now or 50 years from now or whatever. That's no way to run a country. And there's no way to run a country to be. This panel today shouldn't be about this. It should be about climate change, and it should be about healthcare for everybody. And so we've got to take the Supreme Court out of politics. So all I would say is I agree with Anthony and Neil. I give everybody pack the court, but at the same time, tell the American people, here are some proposals that if you go for, will weaken their ability to get in the way of majority rule. And in the long run, that's good for everybody. And we're willing to take that hit. Because this is what I preached in 2016, when everybody thought Hillary was going to win. Weaken the court now for all time, and America's better off. And I stand by that.
All right, well, unless any other panelists have urgent thoughts about all these important issues, I'm going to go ahead and start wrapping things up. This has been a really incredible discussion, and I want to thank everybody for participating. In terms of American Constitution Society business, we are actively seeking applicants for 1L representatives. So if you are a 1L, or if you have friends who are in law school kindergarten, we really need their participation and reaching out to 1Ls, especially now that we didn't have a normal orientation, for example, where we could make our case. Other stuff that's going on is I think on October 16th at noon. Do you want to mention that, Professor Segall?
Sure. There's a professor at the Antonin Scalia School of Law. I still can't say that sentence. Named Ilya Somin, who is a member of the Federalist Society and a libertarian, and is also an absolute expert on federal-state relationships and federalism and commandeering and those kinds of issues. He's been down here before. We're going to do a virtual event with him where he gives his take, which is mostly negative, on a lot of what the Trump administration has been doing when it comes to the constitutional boundaries between state and federal governments. I'm going to respond to him briefly. He'll speak for most of the time. I'll respond briefly, and then we'll take questions. But Ilya is always a provocative and interesting speaker, and I hope people from both ACS and FedSoc show up for that.
Yeah, it's going to be a really engaging event. And let me see, there's also the national organization is really encouraging chapters to get people involved in two main projects: election protection and canceling classes on election day. So ACS is nonpartisan, and we don't endorse candidates or parties, but we definitely stand for everyone having the right legally, but also just practically the opportunity to cast their ballot. So if you reach out to me, then I'll put you in touch with the kind of ACS Election Protection Task Force and the burgeoning effort to just cancel classes on November 3rd at all law schools everywhere. But all we can really do is Georgia State. So that's all kind of in the works. And if, go ahead.
I'm sorry to do this. I wouldn't be true to myself if I didn't. ACS does support candidates for office, and that's been taken off of the website. When I say support, I don't mean necessarily through money and stuff, but we do prefer people over other people. The Federalist Society claims they don't do that on their website, but they do. And I've been just very public in the last 2 years saying the Federalist Society needs to change that on their website. And we've already changed it on our website. So I don't mean to overstep, but I want to be clear that we admit what we do because the Federalist Society does not admit what they do. And that's very important. I'm sorry.
Yeah, no, that's a big relief because every event I went to last year, there's a big, carefully choreographed dance talking about ACS aligned candidates and Federalist Society aligned candidates and judges and things like that. So, you know, I mean, the courts have become one of the main avenues for political change. And, you know, I think the reason that people join is because they care about the outcomes for Federalist Society and American Constitution Society. So, let's see. I mean, I'm just torn between letting people out when I promised and allowing Adam to ask another question. I think I won't be offended if anyone logs off now, but I'm going to let our friend Adam ask one more quick, concise question to our panelists.
Hello. Sorry. So how can we stop the trend of politicizing the judiciary? So assuming honoring the legislative will as manifested in the statutes is something preferable in terms of honoring the will of the majority, would textualism be more preferable than purposivism? Because that kind of, they would be judges, they claim they're originalists, but they are putting original so-called purposes into the statute. So would textualism, to some extent, deter judges to inserting their personal biases into the ruling?
Can I jump
Thank
in?
you.
I gotta teach, so I do want to respond, and I unfortunately have to hop off. I think that the Bostic decision with whether Title VII is inclusive of sexual orientation or transgender discrimination claims as sex discrimination shows that even if you purport to be a textualist, you can have the same method, but your background is still coloring your views, right? Like, I don't think that Justice Gorsuch was doing any more or less textualism than maybe Kavanaugh and Alito were. They just had different priors coming into it. So textualism doesn't get rid of these things, right? It just, I think, it can show actually how your priors really do factor in, to your thinking, into your thought process. With that, I don't mean to jump off too soon, but I do need to get to class. So thank you all for having me. It's been great seeing everybody, and hopefully I'll catch everyone else's answers on the other side.
Can I respond in two ways to this problem of, let's say, depoliticizing the courts? And by the way, with regard to textualism, texts do not interpret themselves. So any appeal to text or original intent and so forth always still involves some degree of interpretation. But with regard to the politicization of judicial offices, keep in mind that in many other democracies in the world, judges, first of all, are never elected into office. Secondly, they're not appointed in a way where a legislative body has to play any role whatsoever, or where a prime minister plays any role whatsoever in selecting them. They're often selected by a panel of judges. Now, of course, that may raise questions about, well, do we want the judges themselves to have this kind of unregulated autonomy? Does that mean that they're not subject to any kind of accountability and the like? Well, systems have tried to deal with that. But I think what's important, if we want to remove the politicization of the courts, we have to ensure that the courts cannot be packed in a decisive way by any particular administration. And that requires term limits, single terms, it requires staggering of appointments. And in our present case, it does involve enlarging the number of judges at every level in the federal system.
So having wrestled for the last 2 decades with originalism and to a lesser degree textualism, those things don't decide cases. Anthony was exactly right. Bostock's a great example of that. There is no correct textualist answer to Bostock. There's only a good public policy answer. Retired Judge Posner used to say that when you have a text, doesn't matter if it's a statute or a constitution, and then judges are called upon to resolve a case involving unforeseen applications of that text, that is creation, not interpretation. Our country would be so much better off if we could just honestly face that fact, that that's creation, not interpretation, and no method of interpretation is going to make a difference, or has made a difference.
Well, I think that's go ahead.
I was just going to say, I don't think there is a way to depoliticize the courts in any near-term way. I think ultimately the courts would be depoliticized if there was a strong public support for the courts being depoliticized. In other words, if there were electoral penalties for presidents and senators who politicize the appointment process, then they would be apolitical. But I don't see that happening. And as long as the case is that presidents and senators get elected on the premise that I'm going to appoint Federalist Society types to the bench or ACS Society types to the bench, although I've never heard a politician say the latter. As long as that's our dynamic, the courts are going to be politicized, and it's going to get worse before it gets better. In fact, I don't see how it gets better. Practically speaking, we can come up with ways that would do it in theory, but as a practical matter, I just don't see it.
I think we should close it out here. Thanks so much, everybody who could make all or part of this today. If you need to get in touch with me or the rest of the ACS board, I'm going to go ahead and put just various contact information in the chat. So just stick around for like 30 more seconds and that'll be available for you. So thanks again, everybody, and hope to see you soon.
Thanks, Alex. Great job.
Thanks, everyone. And I definitely learned something today. See you all.
Bye.